Let's dive straight into a genuinely fascinating constitutional clash. Picture this: a severely underfunded school going head-to-head with a government that is desperately trying to tighten its belt. We're looking at a landmark legal dispute out of South Africa that asks a really critical question about the separation of powers. Basically, when a government slashes spending, at what point can a court actually step in and say, hold on a second, you didn't do that fairly? It's this incredibly delicate balance between politicians managing a national budget and everyday citizens demanding administrative justice. Agenda Item 1, the school funding dispute. Then 2, can courts review budgets? 3, the 3 budget questions. 4, legislative versus administrative power. And finally, 5, the Constitutional Court's verdict. Section 1, the school funding dispute and the plight of EduCollege. So, EduCollege opened its doors in 1995, specifically to serve learners from poor communities in the Eastern Cape. Because of this, they were almost entirely reliant on government subsidies just to, keep the lights on and the teachers paid. Now just listen to these numbers. Back in 1996, EduCollege was getting 1,560 Rand per primary school learner and 2,340 Rand per high school learner. But then in April 1997, those subsidies were just drastically slashed to 700 Rand and 1,000 Rand respectively. We are talking about an immediate cut of well over 50%. Staring down potential financial ruin, the schools sued the provincial government, demanding back pay and challenging the reduction to the tune of 1.25 million Rand. Section 2. Can courts review budgets? The core legal dilemma. When EduCollege brought this lawsuit to the High Court, the government pushed back with a massive institutional defense. They argued that this reduction was based on funds appropriated by the democratically elected provincial legislature, and because of that, they claimed courts had absolutely zero jurisdiction to adjudicate the matter. They were basically saying, hey, we're politicians passing a budget and judges can't just second-guess our math. Here is where Section 33 of the South African Constitution comes into play. This section guarantees everyone the right to administrative action that is lawful, reasonable, and procedurally fair. But there's a pretty big catch. While courts can rigorously review administrative action for fairness, they generally cannot interfere with legislative action. Those broad, policy-driven laws and budgets passed by elected officials. So this entire case hinged on one massive question. Was the decision to slash EduCollege's subsidy a legislative act or an administrative one? Section 3. The 3 budget questions. The macro to micro funnel. To sort this out, the court essentially broke the budgeting process down into 3 distinct steps. It's like a funnel, moving from the massive, untouchable education budget at the very top, down through a departmental estimate, and then finally down to a highly specific student subsidy formula. Let's walk through exactly how the court evaluated each of these steps. At the absolute top of the funnel, we've got a massive number, 5.45 billion Rand. This was the global education budget allocated to the Eastern Cape Department of Education in the 1997 Appropriation Act. The Constitutional Court looked back at a previous precedent, the Fedshire case, and determined that when a legislature determines appropriations out of public funds, it's exercising a power that is totally unique to elected bodies. Therefore, allocating that 5.45 billion Rand is strictly a legislative act. It is completely unreviewable by a court under Section 33. Dropping down a level in our funnel, we hit 8.45 million Rand. When the appropriation bill was first tabled, it came with an explanatory memorandum, which was colloquially known as the White Book. This White Book contained expenditure estimates, showing that out of those billions allocated to education, exactly 8.45 million Rand was estimated to be spent on independent schools that year. And by the way, that was a pretty stark drop from the 10.32 million spent the year prior. You might think a mere estimate is just administrative paperwork, right? Well, the court totally disagreed, because this White Book estimate was actively debated by the politicians in committee, and because it formed the actual foundation upon which the final Appropriation Act votes were decided, the court ruled that this was also part of the legislative process. Consequently, the allocation of that 8.45 million Rand was deemed a non-reviewable legislative action. So the government was definitely winning so far. But the final step in this funnel is where things get genuinely fascinating. Once that 8.45 million Rand was officially allocated, a single official, the member of the Executive Council, or MEC for Education, used their power under Section 48(2) of the Schools Act to decide exactly how to distribute it. The MEC created a specific, uniform formula determining exactly how much money each independent school gets per child. Section 4. Legislative versus administrative power. Drawing the line. To decide if setting that final formula was something a judge could review, the justices had to strictly delineate between these two types of power. If we break this down head to head, it becomes pretty clear how the court views them. On one side, legislative power is deliberative, it's political, and it involves broad policy formulation by elected assemblies. On the other side, administrative power is all about taking those laws and actually implementing them, allocating specific resources, which makes the action subject to procedural fairness rules. And the court really kept in mind that in a young democracy facing immense transformation, the state absolutely needs to efficiently manage limited resources without having courts paralyze every single decision. Writing for a unanimous court, Justice O'Regan leaned heavily on a major precedent involving the president and the South African Rugby Football Union, or SARFU. She used this to remind us that we must look primarily at the actual nature of the power being exercised. It honestly doesn't matter that the MEC is a high-ranking elected political figure. What really matters is the specific task they are performing at that exact moment. Are they making broad policy, or are they just implementing a law? So, applying this logic, the court reasoned that the MEC's formula wasn't legislative at all. Why? Well, first off, the precise formula was never debated by the legislature. Second, it didn't just happen automatically. The MEC actually had various options. He could have easily means-tested parents so wealthy families didn't get subsidies, or he could have means-tested the schools based on their cash reserves. But instead, he actively chose a flat rate. He was performing a specific administrative task within the statutory power of the Schools Act, constrained only by the budget lid the legislature gave him. Now, the government tried one last legal maneuver here. They pointed to a previous case from Mpumalanga, arguing it proved this type of funding was a political, non-reviewable decision. But the court completely flipped this on them. That Mpumalanga case actually proved the exact opposite. It established that when a government retroactively cancels subsidies, they trigger a legitimate expectation from the schools. And when you trigger a legitimate expectation, you are legally bound to provide procedural fairness, like, giving the schools reasonable notice or at least a chance to be heard. Section 5. The Constitutional Court's verdict. The final ruling. The court delivered a really decisive verdict here. They ruled that setting the 700 Rand and 1,000 Rand per student subsidy was indeed an administrative action under Section 33 of the Constitution. Because the MEC was implementing a specific statutory power and making allocative choices that were never debated by the legislature, his actions were purely administrative. And that meant the High Court absolutely had the jurisdiction to review the formula to see if it was fair. But wait, the government had one final desperate argument up their sleeve, the empty wallet defense. They essentially told the court, look, even if you want to rule against us, you literally can't issue an order to pay Edu College because we already spent the entire 8.45 million Rand allocated for independent schools. The money is gone. The Constitutional Court firmly rejected that excuse. They basically said, look, an empty budget does not excuse a government from its legal obligations. The mere fact that a government hasn't budgeted for a payment cannot somehow strip a court of its power to declare an action unlawful. Now, the court did acknowledge that a government's actual ability to pay might influence what the final remedy looks like down the line, but simply running out of money doesn't magically make an unfair administrative act legal. So in the end, the government's appeal was completely dismissed, and they were ordered to pay the legal costs. Because the Constitutional Court was only asked to rule on the question of jurisdiction, this ruling finally opened the door for Edu College to return to the High Court. Armed with the Constitutional Court's backing, the school could now argue on the facts that the massive, sudden subsidy cut violated their right to procedural fairness. To wrap up this explainer, here are the major takeaways you absolutely need to remember. First, the Constitution fiercely protects administrative fairness. Second, while courts will absolutely respect the separation of powers and won't touch a broad global budget passed by politicians, they for sure will step in when it comes to the specific implementation of that budget. If an official has options on how to distribute resources, they are performing an administrative task. And most importantly, the actual nature of the power being exercised matters so much more than the political identity of the person doing it. I'll leave you to ponder this delicate balance of power. In a struggling economy where state resources are stretched incredibly thin, at what point does enforcing strict administrative fairness actually paralyze a government's ability to govern and adapt? It's a fascinating, maybe even slightly terrifying tension between the hard realities of a budget and the unyielding demands of justice.